I thank the chairman for yielding, and I also want to recognize the previous chairman of this committee, Ms. Bono, with us today, who have worked so diligently on this issue through the years. I appreciate the guidance and the leadership there. I also want to commend Mr. Welch, who has been co-chairman of the Privacy Working Group and the chairman for allowing the Privacy Working Group a full 2 years to dig into this issue and to see where we could find agreement. And that is the basis of the draft legislation that we have before us today. The reason it's important that we do something now is because 2014 was dubbed the year of the breach. Think about the number of breaches that were out there. Our constituents have begun to see this firsthand. It has affected someone in nearly every family. And what they are saying is the issue is getting out of control, and we need to take steps to put the guidance in place so that individuals will know they have the tools that are necessary to protect their data and, as I say, their virtual you, their presence online. And I appreciate Mr. Welch and the work he and the Privacy Working Group did to help us come to this point, and I yield the balance of my time to the gentleman from Vermont.
Chair recognizes the gentleman from Michigan, chairman of the full committee, Mr. Upton. Did he about Ms. Blackburn, then you're recognized. 5 minutes for questions, please.
Thank you, Mr. Chairman, and I want to thank our witnesses for being here. Mr. Johnson, to you first. Please get your facts and figures all in order as Chairman Burgess asked, and get that back to us. It is helpful to us, and we were hopeful to have that information today, to be able to define the number of data security cases that you all have brought forward, not just terming it scores and scores. So let's tighten that up for the record. Ms. Rich, to you, you talked about the 55 cases that you all have brought forward. So I want you to walk me through what is the criteria that you utilize when you decide to bring a case forward. What goes into that decision matrix?
The core concept in our data security program, and we have several different laws we enforce, is reasonableness, and not whether there's been a breach. And we have emphasized a process-based approach that's tech neutral. So for years, our education and our cases have been emphasizing that the key to data security is to follow certain key, basic common elements. Put somebody in charge, make somebody responsible for the program. Do a risk assessment to determine what are the risks in your business, not some checklist that another business with a totally different business model is using. Develop a program to address the risks you've just found and focus in particular on things like the key areas.
Let me interrupt you there.
Yeah.
Would you consider then that this is more along, you all have an informal set of best practices that you refer back to? Would that be a fair statement?
Yeah, it's not really informal because it's been widely publicized in the education materials we put out, in our complaints and orders, which all reiterate these same elements.
Okay. All right, let me ask you this then. Do you think the draft legislation would limit the FTC's Section 5 authority?
Well, there is a savings clause, and we're happy about that. But, as we understand it, this is a discussion draft. And so right now, we have some concerns that it might weaken the protections that are currently in place. But with the some of the suggestions we've made for strengthening the bill, we believe it could be quite strong.
Okay, so you would rather, okay, let me ask you about this. Then, what about consent orders? You all have to go ahead and get that consent order to obtain civil penalties for unfair or deceptive practices. So do you believe consent orders are a strong incentive for industry for instituting data security civil penalties?
You're making an excellent point, which is that the bill's inclusion of civil penalties is critical, and we are very supportive of that. Right now, as you note, in order for us to obtain civil penalties, which we believe are an important incentive and deterrent from bad behavior, we have to obtain an administrative order first, and then if there's a violation, obtain civil penalties. So yes, you are absolutely right that civil penalties are a key ingredient to the success of legislation.
Okay. With that, I am going to yield back my time, Mr. Chairman, so we can move on with the rest of the questions. Thank you all, and I appreciate the conversation and that you would be here and weigh in on the discussion draft. Mr. Leibowitz, I have to say it looks normal and natural to see you at that witness table, and we're happy to have you back. Ms. Weinman, I want to come to you first. We haven't talked a lot about the third-party notice obligations. So I would like to have you walk through what you see as the strengths and weaknesses of the third-party notice obligations.
Thank you for the question. I'll begin by setting the stage with some defined terms. So the covered entity is generally the entity that has the relationship with the customer or the consumer, use whichever word you're more comfortable with. And then the third party, or another term used in here would be a service provider, is the one that might perform services on behalf of that covered entity, but would also have personal information in their possession as a result of their B2B relationship with the covered entity, business to business. So the gap that I pointed out in my oral statement is that it's unclear when the covered entity would be required to provide notice to its customers when the third party suffered a breach. It's very clear when the covered entity would have to provide notice when it itself had been breached. But when the third party had been breached, it's unclear whether the timeline begins when that third party has had the opportunity to determine the scope of its breach and had taken steps to remedying vulnerabilities and restored its systems.
Okay. Let me ask you something else. You mentioned the amount of compliance time with businesses having to comply with all the different state laws. So is there any way that you can quantify what this would save to businesses by having preemption in place and having a national standard? Have you thought through it in that regard as the cost savings to business?
I don't have a quantifiable number in terms of compliance costs. That's not something that I have put together. I can point out, though, in terms of the compliance costs would be considerable considering the legal time, the redirection of resources that could be devoted to other critical areas once a data breach occurs is also a question of opportunity cost. If you're spending a lot of time figuring out your notice regime with 51 different frameworks, that is taking time and money away from other areas that you can be focusing on following a data breach.
Mr. Duncan, I saw you shaking your head. Let me come to you on that because you mentioned in your testimony that you all have for years called on Congress to do something on breach notification. You also talk about modeling a federal bill on strong consensus of existing state laws, and in the context of third-party notification, all of the existing state laws require notice from a third party to a covered entity after a breach. So I want you to talk to me about two things. I want you to reconcile your support for a national standard based on the state laws with your issues regarding the structure of the state laws for the third party. And then also I want you to talk a little bit about cost and the preemption and what it would do to, what it would save consumers and businesses in the process.
Thank you, Congressman Blackburn. There are those are three very good questions. In terms of the states, virtually all of the states do have an arrangement by which third parties would report directly to the entity for whom they were providing, say, a service. And that would be the general rule. What has become increasingly clear to a number of state attorney generals is that trying to provide notice like that in every situation actually will not provide effective notice. There is an example, for example, in our testimony that talks about the Heartland breach, which was a huge breach, 80 million data points, I believe, released. And in that case, Heartland did the right thing. It didn't follow the state laws. In fact, it went beyond them and provided the notice itself directly. Had they done otherwise, because Heartland was a payment processor for hundreds of retailers, it would have told each of them, and each of them would have had to tell all their customers about Heartland's breach. So consumers would have received hundreds of notices for what was actually one breach. So there's becoming a realization among the state AGs that we really should be focusing on effective notice rather than this structured notice that's contained in some of the state laws. So it's an evolution of that. This presents a double problem when we go to the subset that Ms. Weinman just talked about, which was service providers, because in this case, under the draft language, in some circumstances, they would provide no notice at all. And that certainly shouldn't be a situation that someone who knows they have a notice, knows they have a breach, can find themselves in a situation in which they say nothing to anyone, not even to law enforcement. And finally, as to costs, this is a very significant consideration. You must consider that this law is going to apply not just to the largest companies in America. It's going to apply to the first person who has 15 dry cleaner front shops. How much will he or she have to stay up at night wondering about whether or not they have met an amorphous data security standard to going forward? And that imposes tremendous costs on the operation of our businesses.
Mr. Chairman, my time has expired and I will yield back, but I would ask Mr. Leibovitz, I could see that he was trying to respond to that, just to submit in writing his response, or someone later can call on him for his response to that question.
Thank you.
Chair, thanks, the gentlelady. Gentlelady yields back. I recognize Ms. Schakowsky, 5 minutes for questions, please.
Thank you, Mr. Chairman. I haven't heard